I was able to focus on the identification evidence in the video, which was very grainy and did not make out any face of any of the accused men. And I pointed out that particularly the third accused, and who they are saying in the video is the third accused, whom I represent, was not identified by any of the other witnesses that attended in this trial. So there's no proper identification evidence. I also submitted about the DNA evidence, the way it was collected, and the fact that it wasn't collected from a crime scene, that it cannot count as evidence against my client. I focused on the faulty investigation that went nowhere as far as I am concerned, and a couple other legal points that I hope the judge will consider and enter a verdict of not guilty for the third accused man, Keiron Fernandez.
I believe it was your position and that of a couple of your colleagues that the circumstantial evidence brought by the Crown was not weaved together sufficiently to prove that your client or even those of your colleagues, represented by your colleagues, committed this murder.
Very good question. Let me break it down for you so that even a baby could understand. Think about it like a rope. You have one piece of evidence, identification. You have another piece, DNA. You have another piece, investigation. You must tie all those strands together like a rope. And if the rope is tight, then you have proved your case. We are saying that the rope cannot be woven together. Therefore, there is no circumstantial evidence and the case fails.
No, for you guys, the attorneys representing these men in this very extended trial, it must be a relief that closing arguments are over and the judge has reserved her decision.
I will be relieved if my client is acquitted. The case is not over. You've heard the judge reserve judgment for before the end of the year. The relief will come from me if my client is acquitted.